In the last lecture, we talked about the law in relation to charities, but we didn't get a chance to talk about the Cy-près doctrine, which is really important. I guess the first place that we need to start with is, what does Cy-près actually mean? Well, it sort of comes from the French word for so close. And for our purposes, what we're saying is that we don't want charitable trusts to fail. People are trying to donate to a charity. We want that money to go to a good cause. And so in situations like that where it looks like the trust may fail, the courts can amend the trust so that it succeeds and the money or the property can go to a charitable cause. However, we do have to bear in mind that the courts do have limits to where they can step in. So if a trust is impossible right from the beginning, then that ends, as you would expect within the law of equity and trust, it ends with a resulting trust, and the money or the property just goes back to the settler. And we saw that in the case of Re Rymer of 1895. So Cy-près can be applied where there is a general charitable intention. We have Biscoe and Jackson, which tells us this. But the opposite side of that is that where someone specifies that they want money to, say, go to a particular charity, but it turns out that the organisation that is specifically named isn't in fact a charitable organisation, it's not registered as a charity, for example, then Cy-près cannot be applied in those circumstances. However, Cy-près can be applied where the property passes to a charity and then that charity ceases to exist. So the final point that we need to make is that the underlying purpose must be exclusively charitable, and this was applied rather strictly in Chichester Diocesan Fund and Simpson in 1944. In other words, if the purpose of the trust is charitable and other purposes, as we saw in the case of Blair and Duncan in the last lecture, then that would fail. However, a more generous approach was taken in Re Clarke 1923, and in that particular case, they said that all of the charitable parts of the trust can be applied Cy-près, and the other parts which are non-charitable would end up being a resulting trust or failing. So the other thing that we mentioned in the last lecture is that the most important statute is the Charities Act 2011. And according to this particular piece of legislation, there are 6 situations where the Cy-près doctrine can actually be applied. So we'll go through these in turn. 62(1)(a)(1) basically says that the purpose has been fulfilled as far as possible. And in Ironmongers Company and Attorney General in 1844, the original class of beneficiaries had dwindled significantly. And so the purpose of the charitable trust had already been fulfilled as far as possible, and so the remainder of the funds could be applied Cy-près. Moving on to 62(1)(a)(2), the purpose cannot be carried out within the spirit of the gift. And this idea of the spirit of the gift is a bit of a loose term, but I think that we can explain this quite well with Re Lycett in 1966, and this is probably one of my favourite cases in the whole of charity law. In this particular case, someone left money to the Royal College of Surgeons, but they said that the money could not be used to help any women, any Catholics, or any Jews. And so the court said that the spirit of the gift is really just to give money to the Royal College of Surgeons. They turned around and said, well, we think it's really great that you want to give money to the Royal College of Surgeons, but we're not sure about the whole misogynistic, anti-Semitic part of your charitable gift. So the courts basically turned around and said, well, we're going to cross that bit out and pretend it doesn't exist, and so we're just going to give the money to the Royal College of Surgeons to do with what they like. 62(1)(b), the purpose only provides for use of part of the gift. We have North Devon and West Somerset Relief Fund, and this is a 1953 case to do with a fund that was set up to relieve people who had suffered from flooding damage. So that explains that. A few more to go through. 62(1)(c), the property can be usefully applied alongside other property for similar purposes. Again, this is rather self-explanatory. Basically what we're doing here is we're taking the property that has been provided within the charitable trust, we're looking at other property perhaps alongside it that has been set up for a similar purpose, And we're basically saying, actually, if we put those two pieces of property together, we can actually achieve the charitable purpose in a much better fashion. 62(1)(d), the area of the original purpose no longer exists. Pegs and Lamb is quite an interesting case. This was to do with a fund set up, a piece of land that was actually set aside for the freemen of Huntingdon and their widows. And the problem that occurred with this is that over time, the value of the land increased greatly, but the number of people actually sort of went down because these free men of Huntingdon died and so did their widows. And it got to a point in the early 90s where 15 people were sharing £550,000. And that was clearly excessive and beyond the realms of sort of charity or just helping people out. So what the court did was they looked at the trust and they said, well, actually, rather than just the free people of Huntingdon, maybe this trust should be reconstrued so that it's helping the people of Huntingdon generally. And so that was the way that the court adjusted the charitable trust in those circumstances. Finally, the original purpose is already provided for. So in Oldham Borough Council and Attorney General in 1993, a piece of land was left to set up a playing field. However, the land was much bigger than it needed to be, and so there was already provision for a playing field to exist on the land, and so the rest of the land that wasn't needed for the playing field could be sold for housing or under a compulsory purchase order, for example. So that covers the Cy-près doctrine. If you're answering charities in an essay question, this is perhaps something to consider, because maybe it's a little bit controversial that the courts are allowed to amend a trust which someone has specifically set up perhaps for a specific purpose, and then this is being amended by the courts. However, the other side of that argument would be, well, people are setting up these trusts to help people, and the courts are just helping that charitable purpose along a little bit. If you're answering charities in a problem question, you may want to sort of look out for this. When you're examining a trust in a problem scenario, think about, can this trust actually be applied correctly and in its entirety, or will the courts need to step in? If so, which area of one of those 6 areas of the Charities Act will actually apply? Great, so that's all of the charity stuff done and dusted. If you did enjoy this video, remember to leave it a like, subscribe for more videos in the future. Any comments, queries, suggestions for other videos, then leave those in the comments below and I'll definitely try and get back to you. Thanks for watching. Bye!